Pulse chain.
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 We have some updates on the court case, SEC versus Richard Schuler, aka Richard Hart. There has been some entries, and if we head down to the latest updates at the bottom here, we find number 34 here. So entries on the 28th of March and 29th of March, but this one just says order. So there's two main documents here. Letter motion to stay by Richard J. Schuler. So there's a stay, and Exhibit A pre-motion letter. So we have a good quick summary here from HEXscout, so I'll just show you that. Lawyers have filed two significant documents in his legal proceedings. The first document is a request for a complete halt to the discovery process pending the decision on his impending motion to dismiss the case. And the second document, a pre-motion letter, seeks a preliminary meeting with the judge. The aim is to discuss and articulate the grounds on which they argue for the dismissal of the SEC's complaint against Richard Hart prior to a comprehensive court hearing. So the arguments presented by his lawyers are clear and undeniable facts. In a humble opinion, this marks another significant milestone on the path to success. So that's the words of HEXscout. If we go over to the document now, this is document 1, March 28th. This is a document from the lawyers to Judge Kuo here, and it says, Defendant Richard Hart respectfully submits this letter to request a stay of discovery pending a ruling on his forthcoming motion to dismiss, for which the court has already set a briefing and hearing schedule. The parties have met and conferred regarding the possibility of limited discovery while his motion is pending, but the SEC has declined to agree to any such limitations. For the reasons set forth below, a complete stay of discovery is warranted. So they have a case ruling there, which is Palladino versus JP Morgan. That's an old case, and then it says, in evaluating whether a good cause exists to grant a stay while a motion to dismiss is pending, courts in this district consider A, whether the defendant has made a strong showing that the plaintiff's claim is unmeritorious, the breadth of the discovery and burden of responding to it, the risk of unfair prejudice to the party opposing the stay. All of these factors favour a stay. The motion to dismiss will raise substantial arguments for a complete dismissal. The strong showing that plaintiff's claim is unmeritorious standard can also be described as showing a substantial arguments for dismissal. So there's another case here. That is Lawson versus Rubin. The court need not determine that Mr. Hart's motion will prevail. Rather, a stay is justified in his motion raises a substantial issue. This is not a frivolous issue. Raises doubts as to the viability of the plaintiff's claims and is potentially dispositive of the entire action. So there's a few more case law being used there. Mr. Hart's opening brief is due on April the 8th, so that's in about a week's time. Brief will be completed on August the 22nd and oral argument on the 24th of October. See January 18th order. If the court if it would aid the court, counsel are available to present argument on on this request at April 11th, 2024 preliminary hearing or at another convenient time for the court. So let's just scroll down here. The motion to dismiss will make a strong showing that personal jurisdiction may be lacking. Another case law there. The complaint does not contain legally sufficient allegations of jurisdiction, as it does not allege that Mr. Hart set foot in the United States or conducted business there, that he used a US payments network, or that any alleged websites targeted persons in the United States. The allegations concern blockchain publishing software programs that are globally available, which do not plausibly establish that Mr. Hart purposefully directed his activities at the residence of the United States. They're using the Burger King case there. To the contrary, the complaint alleges that only individuals chose to access software available on a global public blockchain network to send cryptocurrencies using that network. That unilateral activity cannot form the basis for personal jurisdiction. Moreover, the complaint does not plead domestic transactions subject to US laws, security laws. The case of Morrison versus National Australia Bank being used there. Mr. Hart should not be subjected to the time and cost of discovery when substantial doubt exists as to whether the court jurisdiction over him and whether the US securities laws apply to these transactions at all. Mr. Hart's motion will also set forth other compelling arguments for dismissal, including that the complaint runs afoul of the First Amendment and that its fraud claim alleges no deceptive conduct. These substantial arguments for dismissal justify a stay. Right, how much? I think we just got one page more. That's just the thing there. So let's go through this last bit here. Discovery will impose significant and potential wasteful burdens on the parties. This factor favours a stay where the breadth of the discovery and corresponding burden of responding would prejudice a defendant if his motion to dismiss is indeed granted. Another court case is there. A stay is particularly appropriate in a complex case in which all parties will necessarily incur substantial expenses. The case is particularly complex and discovery is burdensome, and the court, as the SEC, chose to bring this enforcement action against Mr. Hart. Regarding three different software programs with distinct histories, functionalities, and purportedly associated entities. The only common thread is having the same alleged founder. Discovery into all three would entail imposing on Mr. Hart and the court the burden of sprawling cross-border discovery practice concerning nearly 5 years' worth of events. The SEC must establish jurisdiction over Mr. Hart through purposeful direction towards the United States domestic transactions and an investment contract as to each program. If the SEC fails to do any of the three If the SEC fails to do so for any of the three programs, claims regarding the program will be dismissed and related to discovery becomes moot. Waiting to determine which, if any, survive the motion makes sense because even in the event that some of the causes are dismissed, by staying discovery now, it will serve to substantially reduce the economic burden of full party discovery. Another case law being used there. So there's two last points there. We'll just go through this. Beginning discovery now risks prejudicing third parties. The SEC puzzlingly named the three blockchain software programs as defendants. Pre-motion letter part discovery should not begin while the existence of 3 out of 4 defendants is a disputed threshold legal question. Doing so would raise serious logistical and fairness concerns because these defendants are open source software programs executed by thousands of people. PulseChain.org. The petition has got over 44,000 signatures now. So yeah, I remember when that was going on. If they are adjudged to be entities capable of litigating, the court will need to determine how their interests should be protected and what roles their users may and or must take in the litigation and discovery. Fairness demands that these questions be resolved before discovery commences. So that's the first document there. You have all the legal team at the bottom there. And this second document, which says Exhibit A, I think this is something that is from the January of 9th. So this is an older one that I think one of the initial documents we've already been through. So we won't go through this. So as you can see in there, to summarize, Richard Hart is trying to get a stay, so to halt the proceedings in the case, to halt the discovery process pending. So that is the latest update from the court listener for March 28th and March 29.